Were you present to see what was going on?
I was there every day that they were there. I watched what they were doing. Physically not able to do all that work.
Right, I get that, but are the painters going to be here testify?
No,
because all of this is hearsay.
Well, he can testify as the amount of money he's paying to have something done.
Maybe, but he's also saying he's got a contract and the necessity of it being done. They have a right to challenge. I don't have the painters here. I mean, they're the ones telling him that's what needs to be done. Or am I missing something?
He's relying upon his knowledge of what paint looks good and what paint doesn't look good and how he can solve the
I
problem.
don't even know what that means. Somebody is coming in and doing the work.
What starts as a simple landlord-tenant dispute quickly spirals into a courtroom chess match over propane tanks, handwritten math, lease loopholes, and who really owed what and when. On one side, a landlord claiming thousands in unpaid rent, utilities, and damages. On the other, tenants arguing they were never given clear numbers, never shown proper documentation, and were held responsible for fuel purchased before their lease even began. This case is packed with contradictions, shifting agreements, and one critical question Judge Simpson keeps circling back to. How were the tenants supposed to know what they owed if no one ever gave them a clear number? From disputed propane calculations to partially painted walls, verbal side deals, and lease clauses that may say more than the landlord realized, every answer seems to open a new problem. Watch closely, because this case isn't just about money. It's about credibility, documentation, and whether verbal understandings can survive courtroom scrutiny. And by the end, you'll want to decide for yourself. Was this a reasonable landlord trying to recover losses, or a case built on assumptions that don't hold up under oath?
State your appearances, please.
For the record, Tom Ellis, appearing on behalf of the plaintiff.
Your name?
Travis Ackerman.
Thank you, Meltzer.
Thank you. All right. Take time for the adjourned trial date. Are we ready to proceed?
Where you take a seat, raise your right hand, you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes.
Did you at one time enter into a rental agreement with the defendants?
Yes.
I believe the court has a copy of the lease agreement.
I have a copy of the lease agreement that's dated December 27th, 2022.
That is correct. What was the rental agreement for that house?
We rented the house and the attached garage. No, none of the other buildings. And the pay was going to be $1,200 a month. And they were, I had purchased the propane, and they were to reimburse me for the propane in the tanks. And the tanks will be refilled again in the summer. The cheapest rate is a summer fill, and they would pay for that after they were filled.
And when they moved in at the end of December, did you go out and read the capacity of the tanks at that time?
On the day they moved, well, actually, January 1st, I believe. I think Travis went with me, but I'm not positive on that. Read the tanks, wrote it down, and calculated how many gallons were in each tank.
So what was your understanding with the defendants as to the propane tanks and the cost of that propane?
We read the gauges on, there's 3 tanks there, 2 1,000s and 1 500. We read the gauges, calculated the gallons. The price was set when I bought the propane in summer of 22. The balance, Travis and I read the tank and we calculated it. And I told them they didn't have to pay it immediately, that they would pay it over some period of time. Maybe $300 a month. I'm not sure the number was given. But it turns out they didn't pay anything on it.
Okay.
The tanks were filled again in the summer of 23.
So how much money is owing to you for propane that was used by the defendants?
Well, after calculating both what was in the tank and adjusting for what's left in the tanks when they moved out, and giving credit for the 3 payments that his mother and stepfather made. $1,889.02 is still owed.
How much of that is,
This is where the propane issue starts to unravel. The plaintiff claims nearly $1,900 is still owed, but listen carefully to how that number is built. We're dealing with propane purchased in summer 2022, before the tenants even moved in, mixed with propane added in summer 2023, and then adjusted again based on what was left in the tanks when they moved out. That's already a complicated formula. But here's the real problem. There's no clear evidence the tenants were ever shown a written breakdown of what they supposedly owed at any given time. Judge Simpson zeroes in on this immediately, asking the kind of question that makes or breaks civil cases. How would they know what to pay? If the amount wasn't fixed, documented, or clearly communicated, it becomes incredibly difficult to prove a default. So ask yourself, if you were the tenant here, would you feel confident writing checks without seeing the math? Or would you wait for clarity that never came?
the amount of propane that was in the tank initially?
Initially on the front page, 1,480 gallons were in the tanks when they moved in.
And how much was in tanks when they moved out?
915 gallons was left in the tanks when they moved out.
Yes, you may approach my bench.
Okay.
It's not the way it works here, Council. You asked to approach. This front sheet, sir, when was this created? This handwritten sheet?
Just before our last hearing, roughly 3 weeks ago.
Was there ever an agreement with you and the defendants in regards to reducing the rent if they paid the propane?
Yes, in January, I believe, we had a kind of a one-way heated discussion on the phone, and long story short, I agreed to a lesser rent, and they were going to move out by May 1st. Contingent on, prior to that, his mother had told me that she would pay, and John would pay the propane bill, and they did pay $500 in December, $500 in January, $500 in February. Then the payment stopped. As far as I'm concerned, the agreement was void after that because it was contingent on continuing to get the propane paid.
So what was the agreement?
The agreement that I would allow them to pay half rent for 4 months. And they understand they would be out by the 1st of May. And contingent on, and the mother had already said that she would pay the propane bill. And they did, like I said, they did make 3 payments.
How much were they supposed to make?
They were just.
This is a pivotal moment. The landlord admits there was a rent reduction, cutting rent in half, but insists it was contingent on continued propane payments. The tenants, however, describe a very different understanding, that the rent reduction was part of a negotiated early exit due to ongoing problems with access, third parties using the property, and confusion over responsibilities. From a legal standpoint, conditional agreements are dangerous when they aren't clearly documented. Judge Simpson presses hard here, trying to pin down exact terms, amounts, deadlines, and proof. And what we're seeing is a pattern: verbal agreements layered on top of a written lease, with no clean paper trail to back them up. Here's the question for viewers. When a lease is vague and side deals are made verbally, who should bear the risk when things fall apart? The landlord who drafted the lease, or the tenants who relied on conversations?
They were going to pay what they could afford, 500 or so. It was not an exact amount until it was paid off. The first month they paid 500, December, January they paid 500, February they paid 400.
Until what was paid off?
The complete propane bill.
Did they know what that bill was?
Yes.
How did they know what the bill was?
I'm sure I told them and showed them.
Okay. So
And
what did you show them, I guess, is what I'm trying to figure out.
Well, I don't have the paper in front of me, but it'd be a calculation like you have on the front page of our exhibit of the propane that was there when they moved in. Propane that was there when they,
I get you, but was there a document that you showed them that told them what they should pay?
can't say for sure, I assume there was. I mean, I'm sure they would have asked for it.
did you know the amount that was owing?
At that time, we did not know what was going to be left in the tanks when they moved out. But the amount that was in there when they moved in and the amount that was added in August or the summer of 23, those totals were there. And there was going to be a correction made, an adjustment.
Okay, but here's my question. How would they know what to pay?
The original bill wasn't paid of approximately $2,800.
Okay,
That wasn't paid. So there's at least that much had to be paid. And then the refill in the tank was approximately $1,700 in the summer.
would you tell them that's never happening again? Okay, so trying to understand this. There's an agreement that they will pay. And their parents are going to help them pay, right?
Yes. Right.
Okay. Part of this agreement is that their rent would be 50%. Correct?
Once the pay on the propane kept going.
Well, but part of the agreement is that the rent is 50%. The other part of that is that they will pay the propane. Right?
Yes.
But how do I know that they defaulted on that if I don't know the amount they were to pay?
Mr. Samanek, how much money was owing for propane in January when you talked to them about this?
Okay, so how do they know that?
I believe I showed them and told them. They have copies or had copies of these invoices.
All right.
Here I show you a list of exhibits with our pictures of your house. Some of those exhibits show the paint job that they did in your house.
Yes,
And you took those pictures.
I did.
And do they accurately reflect the condition of your house?
Yes. These pictures were taken after I believe the day after they moved out.
Okay. I would move for the admission of the exhibits there. The pictures, I believe the defendants have copies of those pictures.
Including the ones that are online for anybody interested in renting a house to see.
May I approach the bench and give the exhibits of the pictures?
Yes. What exhibit number is this?
Pardon me?
What exhibit numbers?
The exhibit numbers are exhibit 1 through, they're not consecutive numbers. Exhibit 1, 2, 3, 4, 5, 6, 7, 8, 9, and 17.
So 1 through 9 in exhibit 17.
Yes, sir.
All right.
Do those pictures show the walls of various colors at one time?
Picture shows partial paint jobs of several doors and walls that somebody had taken a roller and put a dark blue color or dark color, a couple swipes with probably to test the color, several places, and then it was never complete. And another picture shows a room that's painted some color of red that I know I did not approve. And I did not approve the dark blue color.
Did you repaint that house or those rooms which they put that paint on? Or did you hire somebody to do
The
it?
job is being done. It's not totally done yet.
How much money have you spent on the repainting?
Over $1,700 for paint and labor, and it's not done.
Who's doing the painting?
And neighbor Reese and his wife Sherry Reese.
Is there a bill?
I have an estimate for $1,700, and that's what it is. It's an estimate. I have another estimate.
Where's the estimate?
Sorry.
Do you have that estimate with you here?
What provision is plaintiff relying on regarding the painting?
In the complaint?
No, in the lease.
Or damage to the premise?
Sir, was it going to be painted anyway? I mean, after they moved out, wouldn't you repaint before you rented?
Not necessarily.
Was there difficulty in repainting because of the dark colors?
Yes, it required 3 coats over the
Did you do the painting?
I did not do it myself.
Well, how is he going to testify to that, counsel?
Were you present to see what was going on?
I was there every day that they were there. I watched what they were doing. Physically not able to do all that work.
Right, I get that, but are the painters going to be here testify?
No, Your Honor.
Because all of this is hearsay.
Well, he can testify as the amount of money he's paying to have something done.
Maybe, but he's also saying he's got a contract and the necessity of it being done. They have a right to challenge. I don't have the painters here. I mean, they're the ones telling him that's what needs to be done.
This section is a masterclass in evidentiary problems. The landlord claims over $1,700 in repainting costs, but admits the work isn't finished, the bill is only an estimate, and the painters themselves are not in court to testify. Judge Simpson immediately flags this as hearsay, and rightly so. In civil court, estimates without receipts, paid invoices, or testimony from the people doing the work are shaky at best. Even more damaging, the judge makes it clear that if hearsay is allowed one way, it cuts both ways, and suddenly, the entire painting claim is at risk of being excluded. This is a reminder that frustration doesn't equal proof. Dark paint may be annoying, but annoyance alone doesn't justify damages without solid evidence. Let us know, should landlords be able to recover repainting costs without paid invoices? Or is that a line courts should never cross?
Or am I missing something?
He's relying upon his knowledge of what paint looks good and what paint doesn't look good and how he can solve the
I
problem.
don't even know what that means. Somebody is coming in and doing the work. He's talking about what they're doing and the necessity to do that. That's all hearsay, unless I have them here, because they're the ones doing it.
I believe, okay, we'll move on then. When they moved in, was there any discussion about the house and the barns and the farmland surrounding that house?
Yes, I told them that I have a farmer that farms the land. He will be going through the driveway, coming in and out. They have irrigation on that farm, and especially in the summer months, he would be in there pretty frequently. My son has equipment stored in some of the buildings, and another neighbor has hay stored in some of the buildings, and I have tractors stored in some of the buildings. And I told Travis that what he has is the use of the house and the detached garage, not the other.
Did Travis ever give you a forwarding address of where he was moving?
Not right.
Okay, did he ever give you a forwarding address?
I assumed he moved in with his mother and stepfather.
Not the question. Did he give you a forwarding address?
No.
Go ahead, Ken.
So in summary then, what money is owed to you?
Month's rent.
Of $1,200 per month.
What months are those for?
March and April. $293.66 for the electric bill. $1,889.02 for the propane.
I'm gonna go back to a question that I had that I didn't get an answer to. What lease provision is he relying upon regarding the painting? Is that the one that plaintiff's relying upon, counsel? Paragraph 7?
Talking about paragraph 7 of the lease, which provides.
That's about improvements and alterations to the premises.
Yes.
Normally, that's applicable to fixtures. What provides that to I don't. Well, I'll let you make your argument at some point as to how that's applicable to painting, but go ahead.
Okay, I have no further questions to this witness.
I love to approach right here. I'm sorry, I've never done this before.
Right there.
Mr. Samanek, are you familiar with section 9 of the lease agreement that we both signed, access to premises? So can you tell me exactly who within, you mentioned that there were multiple parties coming in and out of the private drive. What part of that is within section 9 as being agreed upon?
First of all, it's not a private drive.
Okay, so beside the point, access to premises. It says landlords or their agents shall have free access within reasonable hours to the leased premises for the purpose of examining or exhibiting the premises to prospective buyers or tenants, or for making alterations or repairs. Is there any language that states exactly what you had just specified about farmers coming in with equipment?
Says the landlord has free access.
To make
The landlord.
repairs, alterations, or to show prospective buyers. Were you doing any of that? Were they doing any of that?
For every document.
Hold on, you got one question, let him in.
Yes, Your Honor. Yes, Your Honor.
My other tenants should have free access also to that main driveway.
So was that written into our lease agreement? That for our awareness?
No, I'm sure you were told about it.
Okay.
You were told that the farmer would be coming through there,
So-
especially in the summertime.
In reference to the lease agreement, what we signed, can you tell me all of the evidence that's been shared about the access to the property, if any of those are within violation or accordance of the lease
I think
agreement?
what you're asking is, those individuals that are coming on and having access to the premises, do they fall within the parameters of paragraph 9? I think that's what you're asking.
That is what we're asking, Your Honor.
I believe they do.
Okay.
How do they do that, sir?
Pardon me?
How does, in your own words, how do their access to the premises fall within paragraph 9?
Okay, access to the premises means the farm. The farm, this rental house is only one piece of the farm. The farmland is a piece, and there's several outbuildings there that are another pieces of the farm. So my people that rent the land from me and rent the barns from me have access through that main driveway. They do not have access to his house or that short driveway that goes from the main driveway to his house. That's the only part that's private for them, is that short driveway, about 50 foot long, from the main driveway up to this one-car garage. That's the part that Travis did not seem to understand.
Well, hold on. So what's the address there? What did they rent according to the lease?
The house,
No, look at the lease. I get your interpretation, and you may have an interpretation of what they rented, but what did they rent according to paragraph 1? That includes that driveway. right?
Do the barns have a different address, Mr. Stanton?
Oh, ma'am, hold on. That includes that driveway, right?
If they have access to the driveway to the house, yes.
Okay, but that's the leased premises.
Barns are also part of the farm.
Well, that may be your other problem. Because under terms of paragraph 1, they leased that entire premises. Didn't they?
The understanding was at the time when we talked about it, is they lease the house and attached garage, that's it.
Paragraph 1, I understand what you're saying is the understanding. But paragraph 1 says precisely that they are renting the. Does anywhere in there say anything about the lease premises or about the house? Or let me put it another way. Does anything in the leasing agreement exclude anything on that property?
Doesn't specifically exclude it, it doesn't specifically include.
No. That can be your interpretation of it, sir. You'll answer my question because the lease premises is that address, right? It doesn't exclude anything on that property. So it doesn't say, for example, that address with the exception of the barn. It doesn't say that, does it?
Doesn't say it accepts it.
Is there any other writing that excludes that's signed by both parties that excludes any part of that property? Go on to your next question.
Your Honor, may I submit some evidence for the painting?
Okay, what do you have?
We have a listing that they had made to rent the house out, and all of the photos show the existing paint, showing that no painting has been done as of March,
It was-
May 23rd,
Yeah, the last update was May 23rd.
with no update of photos.
In the same.
But it shows the existing paint in the exhibits that they submitted to you.
Have you seen that, counsel?
No, I haven't. Today she has pictures, but
You have a copy. Let's provide it to you in another folder.
Do you have them?
Yes,
Well-
he does.
Do you have any objection to those photos?
I would object to, Your Honor, in that is something off the internet in May. And I think if they're supposed to be cross-examining this witness, why don't we ask him when they started the painting? Who put that on the internet?
His associate Melissa.
Well, hold on a moment. Hold on. Counsel, I gave you great leeway in terms of your questions that elicited hearsay. And now you want me to do that with that.
I guess we can accept.
Because, hold it. Because, counsel, if you want to play it that way, we can play it that way. Because here's the deal. Anything regarding that painting, they don't need to provide anything to me. Because all of that is hearsay. The bill is hearsay. All of that's hearsay, because I don't have anybody here. So if that's the way we want to do it, I'll strike all of that. I'll deny that being admitted. How do you want to do this, counsel?
You can have their pictures admitted as evidence, Your Honor. And
That's what I thought. Did you have questions regarding that to you?
I have no questions for that. Just wanted to state that it has not been done.
Got it. Well, let me follow up with that line of questioning. Sir, has the painting has not been completed?
No.
Has it been started?
Yes.
When did it start?
I don't have the exact date, about 3 weeks ago.
So is the house currently being rented?
Your Honor, can I ask a question?
In a moment. Did you have any other questions of this witness?
Yes, sir. Yes.
Go ahead.
I would also like to touch on the section 5 of the lease with paying the utilities. Mr. Samanak, it says that we must pay the propane no later than the 31st of December of the year the propane was purchased. Mr. Samanak, when did we move into this premises?
I don't know the exact date. You signed it on the 27th of December.
So it says that our lease agreement starts January 1st of 2023. And when was the first propane purchase for that house that you're claiming?
Propane that was in the tanks when you moved there.
Mhm.
Purchased in the summer of 22.
Okay, so according to section 5, where in that language does that state that we owe that propane if we did not move into the 2023? Within the lease,
Well,
what does
hold
that
on.
state?
Hold on. Her question is, where in that provision, sir, does it say that?
The only place it talks about propane is in section 5.
Okay, so the question then is, where does it state that they would be liable for what is in the tank before then?
Doesn't say it in the lease. It's what they agreed to before they signed the lease.
Sir, if you look at paragraph 5, right? The only propane that they would need to pay would be that which was purchased in the summer of 2023. Isn't that correct? That was a question.
They agreed to.
Sir, listen closely to my question. When I'm looking at paragraph 5, that paragraph basically says the only propane they need to pay for is the propane that would have been purchased in the summer of 2023. Isn't that what that says? Go on to your next question.
And Mr. Samanak, I wanted to reference the conversation we had in January regarding the reduction of rent. Was the stipulation not that we were going to read the meters and then pay the propane appropriately once we moved out on May 1st?
I don't remember you saying that you would pay them.
We agreed that we would read the propane meters and that we would figure out how much that we owed at the end of our lease. And were we given that opportunity?
Remember that conversation, although we did talk about reading the meters when you moved out
Mhm.
and giving you credit for what was in the tanks.
Okay, and so with that being said, they paid up until February when we asked to have the readers met, and then we read, and then we'll pay you appropriately because we did not know the amount that we owed. It was not clear due to all the handwritten letters we've gotten.
Got a question? Do a question. I don't need a statement.
Okay. How would we know what we owed if we had not read the meters yet?
At that point, you owned almost 100% of the bill, so there's a lot of it could have been paid.
According to section 5, we did not owe 100% of the bill. So how would we know how much we owed until we read the meters at the end of our lease?
You had to go by the numbers I gave you.
Mm-hmm. Correct.
And do you have a date when you would have given us those specific numbers? I know you referenced that there was a document. We don't have a document. So could you provide us with a date in January you would have done that?
I believe I gave you a copy of the bill. The propane was delivered in the summer of 23.
And then we obviously have made a $1,400 payment towards that, which you've admitted. So we have been paying on that. So when have we defaulted on paying the propane?
Now the bill's not paid yet.
Okay, we're in court. So,
Again, of
The gauge
course,
has been ready for a month and a half, 2 months, and you haven't paid a nickel since.
But when did somebody give them a number?
when we made it.
I mean, outside of being here, when did they have a number?
Give them a number.
We were served with court documents before we even moved out, stating that we owed that much money.
You gave them a number when they moved out.
Shortly after.
Where is the writing where you gave them the number they needed to pay?
It was in the original complaint.
Ma'am, not it wasn't directed at the defendant. When did you give them a number? Sir,
I have the exact date in front of me.
did you give them a number in writing?
Probably at our first court hearing. After a very heated one-way conversation with Travis, he said he'll never pay another dime.
Okay.
Mr. Salmon, can I ask what time frame that conversation took place in? Was that the call we had in April after we had already satisfied all payments made to you?
Sorry, it's all that.
So can you reference the time frame that call was made in? Was it in April after we had already made all prorated rent satisfied propane payments to you?
Hold on, folks. What was the propane bill that was paid in, that you purchased in 2023?
Copy of it in the paperwork, there was approximately $1,700.
Okay. And they paid 1,500, right? Or their parents paid
1,400. 1,400, sir.
14. Right?
Mom and dad paid $1,400.
Okay. So at most, then, for when I'm looking at the language of this contract, by December of 2023, they owe $300.
$1,400, paid $500 in December, $500 in January.
I don't care when it was paid. Here's the problem that I'm having. The lease itself indicates that the only propane that they need to pay for is that which is purchased that year. So the $1,700 purchase in 2023 needed to be paid by, according to this, by December of 2023, they needed to pay whatever that bill was. Right?
At its core, this case comes down to documentation, clarity, and the limits of verbal agreements. Judge Simpson carefully dismantles the propane claim by focusing on lease language that ties payment obligations to the year propane was purchased, not assumptions about fuel already in the tank before tenancy began. The rent reduction dispute highlights how conditional agreements collapse without written terms, and the painting claim ultimately struggles under the weight of hearsay, estimates, and missing witnesses. The broader takeaway? In landlord-tenant law, clarity is everything. If numbers aren't documented, conditions aren't spelled out, and agreements aren't signed, courts are left guessing, and that rarely ends well for the party with the burden of proof. Now we want to hear from you. Who do you think had the stronger case here, the landlord or the tenants? And what would you have done differently? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.